Good morning. My name is Chris Galler with the Minnesota Association of Realtors. Thank you for joining us for our risk reduction series. We're privileged today to have Brad Boyd, our legal counsel, here with us today to talk about marketing service agreements. You'll also hear them called MSAs, and they're part of RESPA. And there's been a lot of conversation and discussion about how realtors and their brokers could be impacted by these decisions. Brad wrote a really nice piece for general consumption, picked up by a number of different wire sources, including Inman News, which is probably the biggest in our industry. And he's joining us today to kind of talk about it and give you some information, short piece that you'll be able to use in your business. And again, if you're agents and brokers, you really want to listen if you're involved in these MSAs. So the first, Brad, why don't you discuss what an MSA is and what context they work in so that people understand what the concern is.
Sure, thanks for having me here, Chris. The MSA is basically an agreement between settlement service providers. So, for instance, a mortgage brokerage company and a real estate agent or real estate brokerage might team up and try and do some cross-promotion or joint marketing. And the marketing service agreement is typically a written agreement between the two to reflect that one party is going to provide the other party with some marketing exposure or promotion, and the party receiving that advertising or exposure is going to compensate them in some determined amount that they agree upon.
Perfect. And sometimes people will state things like, well, MSAs are an exception in the RESPA laws, and they're totally legal, and then you hear people on the other side that say, oh no, they're totally illegal, there's no way you can do them at all. Maybe you can correct people or let people know where the firm ground is.
That's right, and I think the reality is somewhere in between. MSAs are neither inherently illegal or inherently legal. It's really a question of how the users are going to utilize an MSA. An MSA typically is an opportunity for two different settlement service providers to try and team up and work on jointly promoting and jointly marketing themselves. RESPA as a ground rule, the very basic premise of RESPA is prohibiting kickbacks and referral fees among settlement service providers. So if I'm a title company and you're a real estate agent, if you refer business to me, of course it may be a natural feeling for me to want to help you and compensate you for that as a gesture of thanks, but RESPA as a federal law steps in and says, no, that's going to drive up the cost to the consumer. As a title company, you can be the recipient of referrals, but you simply cannot pay the party who refers business to you. So marketing service agreement is at its best is an effort between two settlement service providers. You as a real estate agent may say, Brad, you've got a terrific title company. I'd like to promote and market your title company to the people I work with, and I'd like to give you some exposure on my website. That would be a classic example of this joint marketing. Or maybe we send out a direct mail campaign, and you have half of the direct mail branded for you. I have half the direct mail branded for my marketing of my title company. In that instance, we'd have to share costs. I can't take on the responsibility of having the piece produced, mailing it, and giving you credit for half of the marketing promotion without having you pay half of the cost. So an MSA is really an effort to achieve some equity in the fee sharing for the joint marketing efforts.
Is there a way that people can know whether or not they're in a marketing services agreement that's appropriate or correct?
Sure. The difficult environment we're in right now is RESPA enforcement was taken over by the CFPB, the Consumer Finance Protection Bureau. It used to be HUD, and the CFPB has been very aggressive about enforcing RESPA in recent months and years. There have been several major decisions involving penalties of hundreds of thousands of dollars against title companies and mortgage companies. I think many experts in the industry, you and I have talked about this, I think there's some concern that the next shoe to drop may be in the real estate brokerage arena, that the CFPB may say, you know, we've largely focused on title and mortgage, but let's look into what some real estate brokerages are doing. So the only real way to make sure that you're doing the MSA in a way that's as compliant as can be is talk to your broker, talk to your inside counsel, talk to outside counsel, and really review the MSA, make sure that it's not an exclusive agreement, make sure that your fee being paid for any marketing is proportionate to the real marketing value of that you're not having a disguised referral fee, it's not changed by the volume of business that you're expecting to get or are receiving. There's some basic ground rules that can be followed, and I think agents and their brokers should check in with their counsel about those issues specifically.
Hypothetically, let's say I'm a broker and agent in Minnesota, and a mortgage closing company approaches me and says that, you know, we'd like to get involved in an MSA or something. why should I worry about that? Let's say I'm in a suburb of the Twin Cities or greater Minnesota, or operating in a small neighborhood in Minneapolis. Can you put any light on kind of the infractions and why it's a big issue?
Yeah.
Or even those players?
Absolutely. I think RESPA is I think, scary to many in that there are significant civil penalties that can be assessed. RESPA allows for treble damages, which is kind of the fancy legal term for triple the amount of actual damage. And so I think the problem is the way the CFPB is enforcing RESPA today. All of these arrangements are under a microscope, and you never know whether it's going to be somebody else that they're looking at or you that they're looking at. And I think from a real-world perspective, it's a little bit like the comfort somebody has driving down the highway. If the speed limit is 70 miles an hour and the flow of traffic is 73 or 75 miles an hour, it's easy to get sucked into the flow of traffic and to feel like 75 is now okay and that there's going to be no problem for me for exceeding the speed limit. And that works so long as nobody's found you're the one violating. And I think we're going to see the same thing in MSAs, that when nobody in the real estate brokerage world has really gotten picked off by the CFPB, there's a sense of false comfort. And as soon as you, in whatever small town, big town, small brokerage, big brokerage, as soon as you have the microscope of the CFPB looking in on you, I think that the tone of these issues changes.
And there's lots of ways people can turn you in.
Absolutely.
I think people forget that you could be under investigation for something else. The MSA partner that you have, or partners, could be under investigation.
Absolutely.
Consumers. And other employees, people that are jealous of what
Undoubtedly.
you're doing. And so I think a lot of people think, well, I'll just fly under the light, and it doesn't always happen that way.
And you're right, and I think employee shifting can be an issue. If I'm at title company A and I move over to be employed by title company B, and I want to cause trouble to the first title company, I might say, well, I know they had a lot of MSAs that ought to be scrutinized, and that might turn into a complaint with the CFPB.
Last one, and we'll wrap up. What steps can a member take to reduce their risk right now in violating the RESPA or the MSA part of it?
Sure. Well, the good news is there's a lot of good information out there. I think we always recommend that people check in with their broker and check in with their counsel. But the National Association of Realtors put out a nice piece on this at realtor.org. I think we'll have some links to that within the video. And also my article on Inman News, I think, is a good baseline piece of reading. And I think ultimately that the steps are simply familiarize yourself with RESPA. I think we are in an environment now where RESPA has taken on a far more important tone than it perhaps had in recent years. There was a big opportunity with affiliated business arrangements some years ago where HUD was very focused on those, and people then took affiliated business arrangements very seriously and took RESPA very seriously. And I think we're in a trend line again where RESPA needs to be taken seriously. We need to familiarize ourselves with the rules and be attentive to following them.
Good. Well, that's going to wrap up for today. As Brad pointed out, we do have a couple of links that you'll be able to link to. One is Brad's article, which is a wolf in sheep's clothing dealing with MSAs. Also a link to the CFPB, which is the enforcement entity, as well as DOC and others can enforce it. Another link, NAR, has a good video on it and good work that you can read on those particular issues. Last one is next week, Friday, February 27th at 10 o'clock, we're going to do a webinar conference call on this same issue. That way, if you have some general questions you want to ask to us, we can't answer specific legalities of the arrangements you're in, but if you have some curiosities about what happens or whether or not you might be in one or somebody is asking you about it, you'll be able to ask us. Email me, cgaller@mnrealtor.com. We'll send you the information so that you can hook in either by webinar or by conference call. That's going to wrap it up for us today. Thank you for joining us. Have a great week. You can find the links to the information that we've discussed below the YouTube video.